Good evening, friends. I welcome all for this 26th webinar of corporate professional, which we are jointly organizing with NME NR. Friends, as you are aware, during this COVID, we have utilized this time to share knowledge and bring topical interest and to educate corporate India and professionals. Today's topic is also very interesting, and it is a hot topic because there are so many issues and confusion in the minds of noticee. SEBI has come out a settlement scheme 2020 on reversal trading in illiquid stock option. And there are 14,000 noticees are there who has done this type of transaction. And SEBI has especially come out this scheme, which is one of its kind, which is in large number, and the notices are confused that whether they should opt this settlement scheme, and if not opting that, what is the alternative for them. So they are confused on so many aspects. They are worried about the consequences of other laws. So today, to deliberate this issue and solve the queries from the minds of noticees and their consultant, we have invited various dignitaries who are expert in securities law, expert in income tax law, and the capital market. And the most
Sir, you are muted. Hello, sir, you are muted.
हाँ जी अनम्यूट करें.
So today we have with us none other than the SEBI's Executive Director, Ms. Bhavita Raidu. She is in charge of legal affairs and enforcement. Madam Raidu is currently in charge of legal and enforcement. She has been associated with SEBI for 25 years and has experience in various divisions. Tenure in SEBI, she had the privilege of dealing in significant cases and assisting some of the legal luminaries, including Soli Sorab ji, Vanavati, Nariman, Arun Jaitley ji, Chidambaram, and Mr. Datta, and various other senior counsel. In 1997, she had assisted the takeover committee set up by SEBI under the chairmanship of Justice Bhagwati. She has also been associated with the drafting of regulation for mutual fund, depositories, custodians, and foreign institutional investor and settlement regulation. Some of her papers have been published in journals like SEBI and Corporate Law. She had a 3 years assignment with IRDA also. Her experience and knowledge is par excellence in the legal field relating to security law. We welcome Madam for this program from the side of NME and from corporate profession and from all of us and from all the participants. Then we have Mr. M.K. Dugar. Mr. Dugar is the chairman of NME NR. He is a promoter director of D&A Financial Services, Category 1 Merchant Banker, promoter director of Dugar and Associates, Chartered Accountants, and various other companies. He's authored numbers of books, and he's closely associated with several chambers. And he's a member of Corporate Governance Committee constituted by SEBI. He's in board of several leading companies. We welcome Dugarji for this program. Then we have a very learned speaker and my partner Rakesh Gupta. He is ex-appellate tribunal member, and he is one of the most qualified person. He's a CA, CS, ICWA, advocate, PhD, and whatnot. The most important thing with Mr. Rakesh Gupta is that during this COVID period, he has addressed more than 85 webinars across the country, and every day he is sharing knowledge. Most important thing is that when he is sharing knowledge, he is not miser in sharing any point. He is giving questions that what is the issue and then solving this. We welcome Rakesh Gupta ji, and we thank the way you are spreading knowledge across the country. Welcome Rakesh Gupta. Then we have Mr. Vinod Jain, who is the past president of NME, and he is the founder and chairman of INMAS. Vinod Jainji was the council member of the Institute of Chartered Accountant, and he was in various capacity associated with Chartered Accountant. He was a regional council member of the Company Secretary Institute also. He is on the board of various companies as an independent director. He is a chartered accountant par excellence and a knowledgeable person across the various things. We welcome Vinodji for this program. We have Deepika Vijay Sahani. She is a partner and the partner in security law and transaction advisory. Deepika has the experience of 18 years in security law. She is an advocate. She is a company secretary. And the most important thing, she looks after this SEBI related work and security related work exclusively. She was associated with various assignment of various clients and settlement work she is looking after from corporate profession. We welcome Deepika. Then we have Mr. Arun Midda. He's a secretary of NME NR, and Mr. Arun Midda is managing the entire affairs of NME. We welcome all the speakers and friends. Today's program structure will be like this. After Mr. Dugar will give the welcome address, then I'll request Madam to give the presidential address. And then after this, I will give about this scheme, that what is this scheme, because there is a confusion in the mind of noticee that what I have done. So I just want to run through the legal aspects, that what is this transaction, whether this transaction is correct or not, and then what alternative they have. Then Deepika will tell us about this entire settlement scheme, how to do this, what are the issues in this, and how to solve that problem. And after that, Rakesh Gupta ji will cover the taxation aspects of this scheme, because various income tax issues are coming, and people are not only worried about this scheme, but they are more worried about the taxation aspects. So Rakesh Gupta ji will tell. Vinod Jain ji will tell us the industry view, because he has received various representation, various information. He is in the stock market since so many years. So he will discuss the industry issues. After that, we will have a question answer, and we all will give answer for this. So I will request now Mr. Dugar to please give his chairman address.
Good evening. I think everybody will find in your house. I feel privileged to welcome the chief guest, Honorable Madam Babita Naidu, ED of SEBI. Thank you for your sparing time. We have very important interactive section, decoding the SEBI settlement scheme, illiquid stock option. I would like to welcome Rakesh Gupta, himself is author in tax matter. Paul Vijay, we are old friends since last 20 years. Ex-president of Institute of Company Secretary. Vinod Jain, my colleagues, he was also Central Council member of the Institute of Chartered Accountants in India. Further, I am also very delighted that more than 700 people have joined this conference. I think that all can go to Paul Vijay, who is working since last Monday for this conference. Madam, just I want to understand settlement scheme. First, people are confusing about the settlement scheme, equity scheme. This is a settlement scheme because that has been created after a lot of investigation by SEBI. SEBI has created this scheme to resolve the matters, pending matters. So, but some people have given the feedback, the people who have done the transaction of 3 lakhs rupees. So why should they pay 5 lakhs penalty and other charge? The scheme should be such with the minimum help of the lawyers. People can instead talk to SEBI people and settle the matters. Second thing, the important point people are asking whether they go by this scheme. what will be the impact of taxation department on this entity? I think Rakesh Gupta will cover in his speech. My humble request to all the concerned members who are attending this meeting to bring the relevant question and any suggestion which they want to fill in the scheme so they can understand the scheme very well and come forwardly. I conclude the expectation of any positive outcome to a program in the interest of concern with considered viewpoint of thing. I think SEBI is playing very important role in this matter to give the impact of the to resolve the matter, and India is just moving towards as a global exchange. I think I conclude my remarks and thank you everybody.
Thank you, Binod. Thank you, Dugar. Thank you very much. Now I will request our chief guest, Madam Babita Raidu. Please share your thoughts about this and start the proceedings today's program. Madam Raidu, please.
Thank you so much, and good evening, everybody. It is indeed a privilege and my pleasure to be part of this webinar, and I'm extremely grateful to the team of AMNI and corporate professionals for having taken the initiative of starting this entire process of demystifying the very concept of what a settlement scheme itself is all about. I would not be dwelling too much at length about the scheme, settlement scheme 2020, but interestingly, at the very beginning of this webinar, there were some thoughts laid out about the certain intricacies associated with any settlement scheme. So as an enforcement, as a regulatory authority, which has considerable emphasis on enforcement as its functions, I think we need to first of all appreciate that real success within any system depends, especially of an enforcement process, depends largely on constant evaluation and evolution of the various devices and mechanisms that we adopt for this purpose. And I think we are all aware of how overburdened the courts are today. And the resultant delays that it causes is clearly not something which one needs to be, be comfortable about. And therefore, as a public institution where accountability and responsibility plays a very important role, it is time for us to therefore arrive at some meaningful devices that would work at an arrangement which would relieve this angst about a cumbersome process, enforcement process. And therefore, we need to arrive at some sort of a convergence or integration of any judicial decision-making process with an alternate dispute resolution process. Now, I might like to emphasize that the sanctity of any judicial decision-making process can never be discounted. In fact, it is very, very essential. At the same time, we have to be also aware that since the courts, the tribunals, and the adjudicating authorities need to be spared from adjudicating on issues which could easily be resolved by facilitating a process that would go a long way in ensuring a speedier and efficient resolution of disputes, if leveraged properly, then that would definitely contribute to the reduction of the multiplicity of litigation. And this settlement scheme that is being adopted now today is one such step in this process. I might like to add that this settlement mechanism has come out with schemes earlier too in the past. In 2002, we did have a scheme. In 2004, there was another scheme that was adopted, and therefore it is something which is in the public knowledge. But the fact is that settlement, for some reason or the other, has not been clearly understood. And there have been so many challenges that SEBI has weathered over a period of time. But fortunately, we have gained legislative sanctity by the circular that was issued initially in 2007 and thereafter evolved through another circular in 2012, gaining sanctity by by an inclusion of a specific provision in the SEBI Act 15JB, under which the settlement regulations then got enacted. But thereafter, there continue to be certain issues which keep cropping up about the understanding of the various intricacies involved and an appreciation of the legal issues. But fortunately, the courts in the countries have validated our stand. And today, I think there is no such challenges to the validity of any settlement process. In this particular case, what necessitated the SEBI to come out with a settlement scheme, I think is quite well known by all. But just to give a brief recall about how this emerged, is that there were certain instances where a group of entities were found to be trading and consistently making losses by their trading in the options on individual stocks, which were listed on an exchange. These entities appear to be making consistently losses and were being reversed with the same entities, the same counterparties on the same day, and in a few cases, the next day. So the investigation process that was initiated clearly brought out instances where a large number of entities were involved in generation of artificial trades, artificial volumes by executing clearly non-genuine reversal trades, which resulted in the violation of the SEBI Prevention of Fraudulent and Unfair Trade Practices regulation. It was a call for the board to take some step, and the SEBI could not clearly shrug away this responsibility. More so when the Supreme Court had, in the matter of Rakhi Trading Private Limited, categorically come to a final finding that any impugned transactions which are manipulative have to be visited with a penalty. And interestingly enough, when one of these decisions got challenged before the Securities Appellate Tribunal, in the action that got initiated, the tribunal was quick to suggest that perhaps it is time that SEBI consider holding some sort of an lok adalat or adopt an alternate dispute resolution process with regard to this illiquid stock options litigation that was being frequently coming up on appeal. Now, in any case, since SEBI is empowered to settle matters through any scheme where a large number of entities are involved in a similar kind of default, it was time for another settlement scheme to be initiated. And the most, what I would like to emphasize here is that the most influential financial market trendsetters in the securities market, including UK as well as USA, often adopt settlement mechanism as an effective alternate enforcement tool, where almost 90% of the actions that are initiated are settled through this process. It is a process where any defaults that are noted, which result in a violation, could easily be visited by a penalty under the respective charging provisions of the SEBI Act, which could occasionally be extremely high. Therefore, it is very important for us to therefore arrive at a process wherein we understand that through a settlement process, a certain amount is arrived at, which is not a penalty. But at the same time, we have to make an endeavor to ensure that these acts should not be viewed as business as usual endeavors or be compared to penalties that could be levied. And therefore, it is necessary for us to arrive at a certain via medium wherein, without admission or denial of guilt, the matters that could be initiated get resolved through a process. Now, I understand that in this case, there are around almost 14,720 entities which were found to be involved in this generation of artificial volumes. As a first step, in a phased manner, 567 entities were made out to have made profit and losses to the tune of 1 crore and above. So in a phased manner, proceedings are being initiated or are to be initiated. And therefore, any entities who are visited or are likely to be visited with any action, enforcement action, are given this opportunity to resolve this litigation. And I clearly believe that if there is a process in place that will achieve the twin goals of sanction and effective deterrence without compromising on its the very ideal at which it is based, and reduces the effort and the time in pursuing any enforcement action, then it could be definitely be employed in fulfilling our mandate. So I would take therefore this opportunity to state that I hope that this settlement scheme is welcomed by all, and that everyone utilizes this opportunity to take part, get the benefit of this process. And I might add that during my brief stint in the legal profession, I was not too fond of a conflicted approach towards litigation unless it was really unavoidable. So I believe that this settlement scheme in SEBI would definitely serve the purpose for which it has been prepared. And therefore, I thank the organizers once again for demystifying the very process of what the settlement scheme is all about. And I wish you all the best in this process. Thank you so much.
Thank you very much, madam. Thank you very much for giving the insight of this SEBI's mind and the advantage of this scheme. Madam, as you are aware that industry has so many questions also, and I am trying to clear all the points which are there. But in the process, we have received various questions and we are receiving various questions also. So we will compile all the questions and send it to you. And there is a possibility you may take the problems of the industry and try to work out some solution. Thank you very much, madam, for your kind words. Now I'm giving my presentation. My scheme is visible.
Yes.
My screen is visible. Yeah. Okay. So I'm just telling everybody that this scheme, people are little bit confused that I have not done, because so many people are coming and they are saying we have only done 1 lakh rupees profit and say has imposed 6 lakh rupees penalty. So everybody should understand that what is this transaction and what is the penalty in this transaction. Now, no doubt, these are issues connected with the income tax. But when something you are using stock market, then stock market regulator has to come into the picture. And to protect the interests of the market, SEBI has to prescribe something. So law is already in place, things are already in place. But how this particular thing is taking place, I'm just taking through the entire things to everybody. Now, one is that as you are aware, any economic activities if you are doing, then economic activities either in profit and loss. So profit attracts tax and loss you can deduct and you can carry forward the losses. But everything you have to do as per the law. Now, if you see this, what are the legitimate tax planning which are allowed to everybody? That is, you can do genuine business expenditure, genuine losses, merger and acquisition you can do. If you have 2 companies, one is in loss, one is in profit, you can merge, you can demerge, take advantage of taxes, you can invest something, and you can do genuine trading in the security market, and you can get profit and you can loss. So this is the legitimate tax planning which is allowed under the law. Now, there are certain points which are illegal tax planning people are doing, which are avoidance. Few example is you are putting bogus expenditure if there is a profit. You are doing sale skimming, you are reducing sale, booking for fictitious losses. That people are doing and income tax is taking care. But when you are using non-genuine trading in security market and using security market, and that has taken place in the past, booking illegal capital gain tax, long-term capital gain, fictitious trading in SME platform, and trading in penny stocks where delivery and payment has taken place. But there are certain issues in this. So these were the stock market has seen the past cases, and all cases SEBI has put in penalty. Now the new method which has come, the trading in illiquid stock option, which we are discussing today. So now we have to understand what happened in the illiquid stock option matter. Now trading pattern in illiquid stock option, this illiquid stock option, you have to identify it in the option segment. What are the illiquid, where the trading is not taking place. Then you are doing reversal of transaction. Then you are identifying and doing transaction with substantial price difference without any significant basis. 10 rupees share you are selling at 72 rupees. There are same counterparty, and then on the same day you are doing, and then you are creating artificial volume. So this is the trading pattern in illiquid stock option people have adopted. Now, so the question is, what is the problem? What is the problem if I'm doing this, I'm paying STT and I'm doing transaction? So let's understand the anonymous tradings executed in the market, which is the significant, which is the main part of the stock market. Buyer and seller does not know each other. That is one part. Buyer and seller enter the price quantity in the system, and then system matches the order having same quantity price, and the trade in executed on a FIFO basis. Somebody has put in first, and then somebody has put in last. So first it will match if the amount and the quantity price is matching. Then investor execute trade, and they are visible. They can see order book, but they cannot see who is doing the transaction. Settlement is done, and beneficially ownership is transferred from one party to another party. This is the anonymous trading system, which is the crux of the system. Now, what is synchronized trade? 1, 2, 3. I have told you the system. Now, buyer and seller know to each other. They know that I am buying and you are selling, which is not possible in the anonymous system. Parties, it can be possible only in bulk trading and the trading which SEBI allows. Parties punches price quantity in a synchronized manner at a predetermined time. So what they do, both the parties are putting transaction 5,000 shares at 29.30 paisa, and then they are putting the telephone, and then they are saying 1, 2, 3 and punching this. So the chances of executing these trades, because both the price and quantity is same, and then their timing is also matching, 90% time they match. The traders are premeditated, and through these trades, parties breach the anonymous trading system. And to create artificial, because when you do this type of trading, the artificial price volume are taking place, and this is not allowed in the system. Now, how the reversal has taken place in various groups. So Group A and Group B, these both are different group. So A bought 10 shares at 72 rupees, and then A sold 10 shares at 22 rupees. So in the process, A incurred loss of 500 rupees and B incurred gain of 500 rupees. And these transactions they are doing repetitively, continuously with the same party. Now another example I'm giving. This is Group A. They have two companies, two entities, X and Y. So X bought 10 shares at 11 rupees, and then X sold 10 shares at 82 rupees. So X entity incurred gain of 710 rupees and Y incurred loss of 710 rupees. So these types of transactions they are doing continuously, same time and same party they are doing. So X has some profit, some losses, and Y has losses. So they are executing this. Now, what is illiquid stock option? Illiquid stock option is a contract, derivative contract, which cannot be easily sold or converted to cash. And illiquid option, we are very low and no option interests are there. So they select these types of shares and then they execute transaction in this, because you are not finding more transaction. So your transaction then realized the parties did non-genuine reversal trade, gain and or loss. Is my voice is clear? Okay. So the apex court in securities, in one case of Rakhi trading, which Madam has also mentioned, they told that trading is always with the aim of making profit, that if you are doing. But if one party consistently make loss and other two in pre-planned and rapid reverse trade, it is not genuine, it is unfair trade practice. So the court has mentioned that you can make profit, that is your aim. You can get loss also, that is okay. But somebody continuously doing losses, that is not a economic principle which is working out. That is Supreme Court has mentioned. Then if you are doing this type of transaction where the volume and everything you are doing, then these are called non-genuine transaction, and this is creating a artificial trading volume in the market, and where there's a fictitious loss and fictitious gain you are getting. Now, if you see this particular issue is from 1st April 2014 to 30th September, we did investigation of 21,000 entities. And out of this 1,000 entities identified, and then SEBI observation is the system, which is a hallmark of security market. Parties acted abnormally. They made consistent losses, which is beyond rational. Pre-arranged party. So same party you are doing transaction and then reversing, then again doing and again reversing. And this is also in the same day or next day. Trade reverse has a different price without having rupees done. So these are non-genuine, aimed for creating artificial losses and gain. This is the SEBI's observation of this investigation report. Now the question is, I have done this transaction. What I have done wrong? But under the SEBI law, under the securities law, these are called unfair. This is called fraudulent and unfair trade practices. Regulation 341 and 42A of SEBI, which is talking that if you are doing this type of transaction where you are creating false market, you are doing reversal market, you are defrauding the system, and you are creating false and misleading appearance of trading, that is not allowed. So in this matter, we observed that the trade were executed artificial, false, misleading appearance of trading in the stock option market, and hence SEBI observed that such trade were fraudulent in nature and liable for penalty. Because when you do transaction, you don't know who is buying, but here you know doing the transaction with the person second, then you are reversing with the same person. So this is not the genuine transaction. Now, what are the penal provision if you provision as per HA of SEBI Act? Minimum penalty is 5 lakh, maximum penalty is 25 crore, or times of the profit, whichever is higher. That is the law. Quantum we will decide on the basis of what funds you have created, what types of nature of default you have done, what investor lost in this, then they have, and what is the repetitive nature of offense. If this is proved, then SEBI can put penalty more than 5 lakh also. Now, this minimum 5 lakh penalty is prescribed under the section, and FUTP regulation is prescribing that no doubt the AO can reduce the penalty also with the some circumstances that Supreme Court has decided in Bhavesh Parbi case. But that particular point you have to bring out that I have not done this transaction with this intention, that you have to explain. Next, come to this, that not only SEBI put penalty of this 5 lakh and 25 crore, but they can do the prosecution also under section 24A and 24B. But only thing is that particular case will be there when you are doing something which is against with the market and you have done more fraudulent types of transaction. Here the transaction of the nature of they have gained profit. That's why. But this is also a penalty provision which SEBI can impose. Now, if suppose I have done this, and this is the SEBI penalty which I have just told you. So there is a settlement process in SEBI, and that is a regulation 2018 settlement is there. Not this settlement scheme, which this is a normal settlement which you can go. If you are going for this settlement, which is available for all type of transaction, then minimum settlement amount is 15 lakh for FUTP transaction. And if there's a body corporate, then the amount is 1 crore. For individual, 15 lakh, and that is 1 crore for companies. So suppose you have done this transaction and this scheme is not there, you are going for settlement, you have to pay this amount. And these are the key determinant factor. FUTP violation, they give the factoring 0.25, violation in illiquid skip 0.3, financial benefit at 0.25, reputational risk 0.25, and that is combining 105, that factoring they do. And then on that basis, they decide to put the settlement amount. So this 15 lakh rupees is not, this is the minimum amount. They can put the more also on the basis of various factors. Now, entities involved in reverse transaction, if you see this number, there are 21,652 entities had done this transaction. Then SEBI did the investigation, and out of this, they realized that non-genuine transaction and reverse transaction was 14,720 entities have done. That include individual, HUF, body corporate, and brokers. And then SEBI initiated adjudication proceedings for 567 entities and passed order against 700 entities. And then out of these 150 entities, about 70 to 80 entities approached SAT and challenging the SEBI's order. Now, when the 60-70 entities reached to the SAT, then SAT, in one case of RS Ispat Limited, they SAT observed the large number of parties involved in the similar matter. This is a systematic failure. Tax issue is also involved. Most entities were contesting SEBI's order against before SAT to save time of litigation, which Madam has just told, not to overburden the court, and save the time and cost of people also, those who are getting notices. SAT has suggested that if the nature of transaction are same, entities are more, then why SEBI should not bring out some Lok Adalat or some alternative scheme. So on that basis, SEBI introduced this scheme, which has there are the settlement scheme of 2020. Now, what option is there? Type of transaction involved in illiquid option matter. If non-genuine transaction are there, where fictitious loss or fictitious gain is there, trader will be adjudged as a non-genuine, and they will attract legal action as per law. But if you have done the genuine transaction, if you can prove this, now burden is proved on the party. And second is if the date, time, price on which SEBI has determining and quantity of order placement not matching with counterparty, the parties can take benefit, and then they say that I have done the genuine transaction. That proof has to, burden of proof is on the party. Now question is, what option these parties have, those who got the settlement notice? Now, can the party escape the liability? Now the question is, so many people asking, I have done only 1 lakh rupees profit and I got a 5 lakh, 6 lakh rupees settlement amount. What is the option? Answer is no. The parties do not have avail one-time settlement opportunity. They are still liable for action as per law, which is SEBI law. Although the genuine entities can represent their case before adjudicating officer in an effective manner and may get relief if they can prove that I have done the genuine transaction. But if those who have purchased profits, those who have purchased losses, they cannot escape. Now SEBI will issue show cause notice if adjudicating matter. Then people can think, okay, I'm going for adjudication. Then SEBI's view is very clear. So you can try that I can go to SAT and file the appeal. Suppose I'm losing my case in SAT, I can go to Supreme Court. So I'm just telling what SAT is thinking. In the matter of RS Ispat, SAT has decided, and they have given order recently on 14th September. They are saying Buying and selling on quantity within a day is not illegal. But if the trade's done with the ulterior motive, then it is not genuine. One party is making profit, another party is making loss, and that is also continuously. And both are doing transaction on a same day and same type of the same party. Those who are the reversal and contract matching with each other, then they are saying, in our opinion, the trade was non-genuine. And even though direct evidence is not available in the instant case, but it is a peculiar facts and circumstances of the present case, there is a irresistible inference that can be drawn that there was meeting of minds between the appellant and the counterparties and collision with the view of trade at a predetermined price. That is the decision of SET. So you can understand they have realized this. So we have less chance to go to SET. Now we think that we can go to Supreme Court. The Supreme Court also on February 2018 Rakhi trading case, Supreme Court also said trading is always with the aim to make profit. But if one party consistently making loss and two is predetermined a rapid reversal trade, it's not genuine. It is unfair trade practice. And Supreme Court upheld the SET order and simultaneously upheld the 1 crore 80 lakh rupees penalty imposed by SEBI in Rakhi trading case. So this is the Supreme Court mind. Now question is, so many people are saying I have not done something. SEBI versus Kishore Ajmera, Apex Court has analyzed and they said that security fraud or manipulation is not, you cannot say direct and clinching evidence is available, but you have to apply the test of preponderance of probabilities, take into account of surrounding facts and circumstances, and then you decide the case. And this case is not limited what facts available to you, you have to see other things also. So Supreme Court mind is also clear for these types of transaction which has taken place. Now question is settlement versus adjudication. Friends, this particular point which I am giving, this is my personal view. This is not the view of any body. This I'm giving my personal view that settlement versus adjudication, what will happen. If you are going for settlement, then settlement amount will be decided on the basis of number of contract, number of non-genuine trade, and quantum of artificial volume created. That is the, and then settlement factor they will take 0.55 that Deepika will explain. Minimum settlement amount is 5 lakh rupees, that is observed from the trade. If you are not going for settlement and if you are going for adjudication, then they will, adjudicating officer will decide number of contract, number of alleged non-genuine trade, quantum of artificial trade, rationale behind these transactions, unlawful profit you gain, impact of the market, conduct of the noticee, all these factors they will do. And the minimum penalty, the AO is imposing 5 lakh rupees, that can go to up to 25 crore also, depends upon the various parameters. We have done some analysis on the basis of the SEBI side. We took out certain data. Settlement amount as calculated under the scheme, that is coming about the 33 lakh, 39 lakh 83. That is number of transaction, non-genuine, artificial volume. Artificial volume is coming 30 crore shares. So that way the amount is coming like this. Then comparison of penalty imposed and settlement, we have taken out some AO order, and then we did how many number of trade they have done, contract they have done, number of non-trade they have, number of transaction they have done, and artificial volume they have created. So AO penalty was 5 lakh, settlement amount is coming 697, AO penalty 550, this is 20, this is 19, AO penalty 1939 settlement. So this is here the AO penalty is 50 lakh, settlement amount is 37 lakh. So this is a mixy match. This is not fixed that always AO penalty was less or settlement more. Settlement can be less also, settlement can be more also. That is also some analysis we have done. Now, if I conclude this point, that what is the monetary penalty in the settlement scheme, that is 5 lakh to 80 lakh. Adjudication proceed, that is 5 lakh minimum, it can go up to 25 crore. Here, if you file, only you have to pay the settlement amount and your filing is complete, and then some information which you have to submit. But here, you have to go for detailed reply, corroborating material facts, and you have to represent before AO. time completion, here you pay amount and submit document, matter ends. Here you have to take 5 to 6 months, which is normally is taking. Cost, settlement one-time cost may be high, but here monetary cost levy may be less, but it can impair, it can pose greater consequences in longer run. Penalty as if allowed to business expenditure, income tax, that may or may not be, that Mr. Rakesh Gupta will explain to you. Now, if we have done some analysis and we came to know that total entities 14,720, and that out of this 1470, the 90% cases, the penalty of settlement will raise 5 to 10 lakh rupees. And out of this 13 to 48, out of this 50% will be the settlement amount is 5,50,000 rupees. So 90% cases, the penalty will not be more than 10 lakh, and 50% cases, it is 5,50,000. That analysis we have done from the system. Second is, we have to understand the future consequences. If I am filing settlement, then SEBI will not find any fault. They are not, they are facts you can apply without admitting and accepting it. So SEBI is not giving any findings. Entities may face other regulatory orders, and they have to investigate independently the point of view. If you are going for adjudication, then penalty imposed by SEBI, then SEBI will be total or reasoned order also. This genuine, and on the basis of this, the other penalty can also come, and then other authorities can start from that part. Here in settlement, income tax or other authority will start from zero. Here they will start from the order. So income tax issue will come, that Rakesh Gupta ji will explain to you in detail. Then something related. So question, what say? Whether I should go for settlement, whether I should go for adjudication. The answer is not very clear, because somebody wants to contest, but the question is, if you want to contest, you have to devote time, efforts, and then the amount of adjudication versus settlement will be more or less same. So case, and then adjudicating officer impose penalty, and settlement amount is also coming more, because they are on the basis of three factors. Factor is contract, trade, number of trade, and the number of non-genuine transaction. So 90% people can take advantage of this situation and this particular thing. So call you have to take. If you think their transactions are genuine, your transaction can be arguable, and you can put your point that I have not done non-genuine transaction, then you can go for adjudication. But if you think that you have purchased profit, you have purchased losses, then the best way is go for settlement scheme. This is the total conclusion from my side, which I have given the total picture. Now I will request Deepika, please share your point that how this scheme, how you can apply this, and how the people can understand and they can take advantage of this scheme.
Thank you, sir, for giving me this opportunity. Whether my PPT is visible?
Yes, visible.
Okay. Hello, everyone. We have heard a lot about the settlement scheme. Let me just quickly take you through the process of how to avail the settlement and the process therein. Just to briefly give you a background, this settlement scheme is introduced by SEBI by virtue of settlement regulations. There is a provision under settlement regulation which enables the SEBI to come out with schemes for a certain type of for a certain class of entities, and SEBI has come out with this settlement scheme for entities who have involved in trading in illiquid stock option segment at BSE during the period 2014 and 15. So what is the silent features of this settlement scheme? This scheme shall be applicable in respect of those entities who have carried out reversal trades or non-genuine trades on BSE in illiquid stock option segment. The trades have been carried out during the period April 2014 to September 30th, 2015. This scheme can be availed by those entities against whom any proceedings are either pending, or even by those entities against who have not received any show cause notices, although SEBI has sent them their summary notice for parties who have done these trading to enable them to apply to the scheme. Now, this scheme, the validity period of the scheme is from August 1st, 2020, and it is applicable up till 31st of October 2020. So now we are 15 days left for the scheme as of now. Now, what is the application fees for this? For body corporates, it's 25,000, and for individuals, it's 15,000. It is one-time non-refundable application fees apart from the settlement amount which has to be paid.
I think you can switch off your video just क्योंकि आवाज थोड़ा sound problem हो रहा है.
Okay.
Yeah, now it's okay.
So application fees is different for body corporates and individuals, as I just discussed. Coming on to the settlement amount is being calculated by SEBI mainly on the basis of three parameters. One is number of contracts executed by you, number of non-genuine trades out of those contracts, and artificial volume created. Based upon this, the amount which is derived by SEBI, that is further multiplied by a settlement factor which is being taken as 0.55, which mainly comprises of two factors as per the settlement regulations. One is violation in illiquid scrip, that is 0.3, and reputation risk, which is non-admission of guilt, because generally settlement regulations, if we avail settlement, it is on the basis of non-admission of guilt. That is the main purpose of going ahead with the settlement. So that is 0.25 is an additional factor which is added to your amount. Now, what is the procedure of availing this settlement scheme? So to avail this, we have to access this online SEBI portal which is there, and the first thing which you have to do is to check your settlement amount, obviously. So you simply need to enter your PAN number, and when you enter your PAN number, the following screen opens, wherein what is the entity type, how many number of contracts you have executed, how many non-genuine trades were there, and what was the artificial volume which was created by virtue of your contracts. Now, based upon this, what settlement amount you have to pay is also reflected on the screen only. It's calculated and shown. Registration fees, since this is for a body corporate, it's 25,000. So the total amount which has to be paid is also there. Now this screen is also providing you with respect to the further actions which we have to take. That is the files which we have to upload, which undertaking PAN, ITR, which I'm dealing in the later slides. So this is the main screen which opens when we put in our PAN card details. Now to avail the settlement scheme, what we have to do, we have to first submit certain documents online. So what are the documents which needs to be submitted online is the scanned copy of your PAN card. It has to be self-attested. Scanned copy of income tax returns for the last 3 financial years. It again needs to be self-attested by the applicant. Undertaking and waiver. Now this undertaking is to be, the format is already there in settlement regulations provided by SEBI. It has to be uploaded in a scanned manner. It has to be on a non-judicial stamp paper of ₹200 as per Maharashtra Stamp Act, duly notarized, and it can be without admission of guilt or with admission of guilt. I'll just briefly run through what are the major components of this undertaking. So basically, it talks about the jurisdiction of SEBI. It talks about whether that the applicant will not take any enforcement action after the order has been passed. It also talks about that the settlement does not preclude the rights of other parties. Then the legal cost, etc., what you have undertaken to be paid. It also talks about that after the passing of the order, you will not challenge the settlement procedure or the settlement order. And as I was discussing, whether it is through admission of guilt or without admission of guilt. Now, if you see in this point number 10, both the options are there. And while taking out the print of this undertaking, you have to strike off the non-relevant part and let the other part remain. So if you are going ahead with the non-admission of guilt, you have to strike off the admission of guilt. So this is the undertaking which you have to take a print on 200 rupees stamp paper, get it notarized and upload it along with the other documents. Now, payment is to be done on the online portal. Payment amount, the amount of application registration fees and the settlement amount both has to be made online. It's advisable that you preserve the receipt or the screenshot of the online payment which you have made, because that is needed at a later stage. Now, what is very important is that this online process, as per existing norms, is open till 31st of October. So if you propose to avail this scheme, you must avail it by 31st of October. Now, once you have done this online filing and payment, what further is needed? That you make a physical filing as well. Now, physical filing, there is a form which is prescribed under settlement regulation which needs to be filed. What the form essentially talks about: you have to give details of yourself, that is the applicant, whether you are an individual or a body corporate. If you are a stockbroker or SEBI registered intermediaries, and certain additional information is needed to be provided. Then you need to provide the status of your case. So if there's already pending proceedings of adjudication, then you have to give the details of those proceedings. If supposedly your matter is pending before SAT, you have to give status of those proceedings. If it is not, if there's no proceeding, then you can write not applicable. You also have to disclose whether any other action has been taken by SEBI in any other matter against you, against your associate, or if you are a body corporate, then your key management personnel or promoter or director. So those details have to be disclosed in the settlement of this application form. And then what is also advisable while filling in this form is that you give your facts of the case, your mitigating factors, and your justifications and defenses. This will help you, if you avail the settlement here, this will help you to take up this any of the such matter is raised before any other authority, be it income tax or any other authority, if you clearly justify your case here. So again, along with the application form, once again you have to file the physical copies of self-attested PAN card, undertakings and waivers, which we have just discussed, your income tax return, 3 years. Now here you also need to attach the copy of the payment of settlement application processing fees and copy of payment of settlement amount. That is why I said while making the payment, save the receipt or the screenshot of payment so made by you. This physical filing is to be carried out by 5th November 2020. So if you have availed the online process by 31st of October, in next 5 days, you have to fill in this form, attach all the relevant physical documents and dispatch it to SEBI. Now, once you have submitted these documents, then SEBI will analyze and or the relevant authorities will pass a composite settlement order. This settlement order will be treated as a settlement order under the provisions of SEBI Settlement Proceeding Regulations 2018 itself. So your matter will be settled, an order will be given to you, you will receive the order by way of mail, as well as it will be published on SEBI website. A hard copy of order may also be dispatched by SEBI. So while we have been dealing with various clients and other people who have been posing queries to us, so few of the queries which we have come across is, what if we do not avail this settlement scheme? Now, if you will not avail this settlement scheme, SEBI will initiate enforcement actions, which may be in the form of adjudication proceedings. Monetary penalty can be imposed. After this monetary penalty, you always have an option to go to SAT, but it's a long process, legal process. For the proceedings before SEBI, also you have to, a show cause will be issued, you have to submit reply, then attend hearing, and then the order is passed. If you want to challenge, then you have the option of going to SAT and subsequently to Supreme Court. So the entire legal process has to be followed. Can I challenge the settlement amount? No, you cannot challenge the settlement amount, because settlement amount is not a penalty or anything of that sort. It's a it's an amount which you are agreeably be paying to SEBI to settle the matter. So it is not challengeable. I do not have the details of my trades executed. So few of the entities who have received these notices in the earlier phases have not received the trading details. So if you have not received the trading details for which you have received the settlement notice, you can write to SEBI asking for these trading details, and SEBI will send a mail to you enclosing all the trades which you have executed. So what are the key points which you need to keep in mind while deciding and going ahead with settlement? One thing is, analyze your facts and circumstances. Evaluate what is more feasible for you, adjudication or settlement. Pawan sir has given you a detailed process or detailed pointers for this. What you have to be very like, few of the poignant point for determining or evaluating this is who you are, whether you are a professional, a director or promoter of a listed company, a SEBI registered intermediary. Because if you are any of these person or entities, then any adjudication order of SEBI may leave an impact on your professional career, or if you are a listed company, you may be required to disclose it to market at large. It can have a negative impact on your market image. And if you are a registered intermediary, then it can be a problem. You will have to keep on disclosing it, and will also be you have to see your fit and proper person guide, whether you comply with that guidelines or not in future. Other things which are important to analyze is, what are the facts of the case, whether SEBI the trades which SEBI has said that are illegal or reversal, whether they're actually such. You have to analyze from your own data as well. What are the issues and what grounds on which you would like to challenge? Like, there are many people who are coming and saying that we executed these trades on because a broker asked us to do. So when a broker asked you, whether you did not ask them that why they are advising you, and who was the one who was actually placing the orders. So these are the facts which needs to be analyzed. And obviously, what is the amount involved? So what is, based upon your number of trades, based upon your volume, what is the amount which is proposed as a settlement amount by SEBI? A lot will depend upon that as well. Then you also need to effectively represent the mitigating factors, as I discussed before. While making the physical application, in the application you must put in all your factors, like according to you why the trades are not in non-genuine, or they were not reversible, or what you acted at behest of somebody or on advice of somebody, or you deny the charges of the trades being non-genuine. So these things have to be carefully put in your application. And of course, then you need to take the advice of your income tax advisor as well, with respect to your income tax returns, etc., which and what implications it can have. So that's all from my side. So be careful while filing in your application and while availing the settlement scheme. Thank you.
Okay, thank you, Deepika. Thank you very much. Now, time to the our star speaker, Mr. Rakesh Gupta, because no doubt this is a settlement scheme, people have to follow SEBI law, but everybody is asking what after SEBI settlement, whether income tax is a settlement for entire all my ills or income tax will treat it separately. So Mr. Gupta will explain to you about the Mr. Gupta will explain to you about the entire income tax nitty-gritty, whether you are going for settlement, whether you are going for adjudication, what income tax department will do. Over to Mr. Gupta, please.
Thank you, Pavanji. Honorable Chief Guest and my fellow panelists. The topic of a settlement scheme 2020, I mean, is very fine topic in the sense that, I mean, it is somewhat soothing. But then at the same time, the settlement scheme, I mean, is unsettling the mind in the sense that there are genuine concerns or the apprehensions in the minds of those now who are going in or opting for the settlement scheme as to what would be the implications of seeking this settlement on the tax proceedings which have already culminated into the assessments, or because of this settlement their cases may be reopened. I mean, so I thought that I will try to deal with these aspects. So first of all, what can be the tax implications of such kind of trades, I mean, which may have been made? I have been told that futures and options of the derivative transactions which have taken place from 1st April 2014 till 30th September 2015 are amenable to be settled under the settlement scheme 2020. So if somebody has taken or somebody has earned the profits, I would say it like this, and qua that profit he chooses to go in for the settlement, then the tax proceedings which may be there or the tax impact which may be there is on account of the fact that the assessing officers, the moment there is any sum found credited in the books of a person, then the assessing officer is entitled to scrutinize the nature and source of that credit. And therefore, when that nature and source is either not explainable or explained with evidence, then such profit, even if it may have been shown as a profit by the person concerned, may have been offered as a part of the taxable income on which the tax has also been paid, then also the nature of this credit now is liable to be varied by the assessing officer under its discretionary power, and of course the discretion has to be exercised by him and will be exercised by him based upon the justice, equity and good conscience. And once the true nature and source of that credit is not the so-called profit, but then this is the income from undisclosed source, then it has got consequences in terms of section 115 BBE of the Income Tax Act. Now, which for these two assessment years, which will cover this period, assessment year 15-16 and 2016-17, and there, I mean, is the likelihood of the levy of flat tax rate of 30%. And of course, then the interest is a natural consequence. And so far as the penalty is concerned, the penalty as at that time 270(11)(c), which can be ranging from 100% to 300% of the tax sought to be evaded. And then in appropriate cases, then the department can take the matter to the prosecution level also. And similarly, I mean, those persons or entities, I mean, which have shown the losses, and the effect of those losses is or was in order to reduce the incidence of tax by reducing the taxable income, and assessing officer having found the non-genuine character of these losses, now would obviously happen to disallow that loss and would expose the entire amount of profit to tax. And This is another consequence of the disallowance of loss. And once the loss is disallowed, the income is enhanced, then that income will suffer the tax at the rate, which is applicable in respect of that much of income under the particular head of income. So these are the tax consequences of the so-called profits or the so-called losses, which may have been earned or incurred by these persons. But then the next important question is that in case the settlement scheme 2020 now is preferred by these persons. So as I have been told that the settlement is of two types. One is that by admitting the factual conclusions and the factual legal position. And the another is on an extra payment, that settlement is without admitting the factual conclusions or without admitting the legal conclusions. So in case the settlement has been done through the latter mode, that is without admitting the factual conclusions or the factual legal positions, then in that case, there may still be the argument which would be available that this concession or the settlement may not be treated as an admission, and therefore that admission should not stand in the way of a person to prove in the tax proceedings that the transactions undertaken by him were genuine transactions. Obviously, the department will pitch in even this kind of concession, also this kind of settlement against the person concerned. But then the SSE or that the assessing officer, or for that matter even the appellate authorities, can be impressed upon based upon the documentary and the circumstantial evidences that that settlement which has been done under the SEBI settlement scheme of 2020, should not be pitched against him in the tax proceedings, and that should not be taken as a concession or as an admission, because admission is the best evidence against a person. But then if the settlement has been done through the earlier mode, that is by admitting the factual conclusions and the factual legal conclusions, then in that situation, that concession made by a person in that settlement scheme, now that of course will stare at the face of the taxpayer. So this distinction will have to be borne in mind. Now the third thing is that where the department may not have in fact initiated any action so far, but then based upon the settlement, there may well be the possibility that on sharing this information from the SEBI to the tax department, or for that matter the tax department taking out this information from SEBI, then may well initiate the action under section 147 for reopening the assessment. And that kind of an exposure, that cannot be ruled out, though if the settlement has been done on the basis of without admissions of the guilt, then in that situation, you can contest tooth and nail with vehemence by leading evidences, direct documentary and circumstantial evidence, that it is not a case of imposing the tax or levying the penalty. But where assessments have been made, in such cases, then as all of you are aware that there is a Vivad se Vishwas scheme which is open till 31st of December. So any appeal which is pending as on 31st of January 2020, such assessees can avail the benefit of Vivad se Vishwas even under the Income Tax Act also. But then it would have been better, I would say, that the SEBI would have coordinated, or the tax department would have coordinated, and a concerted settlement scheme would have been brought, and the assessees in that situation would have come forward in a much more straight and unhindered manner. But then anyway, still I would, as Pavanji has also suggested, that in case the settlement is made on without admission of the guilt basis, then there is, depending upon the direct documentary and circumstantial evidence which may be available and which are liable to and which are prone to be appraised independently by the appellate authorities, then one can defend one's action. Now there is one more aspect, which the people have asked about, as to what would happen about the admissibility of the settlement fee and the compounding fee, which is to be paid while claiming or while assessing the taxable income, whether it will be an allowable expenditure. Now that is a question now which we have to deliberate at a little bit length. So if a person has entered into the transactions and futures and options and thereby earned profit, then this future and options, dealing in future and options has been considered to not to be the speculative business, because as all of you may be knowing, that says section 43 subsection 5 clause D. Now from 2006 has specifically provided that this future and options carried out in a particular manner subject to the fulfillment of certain conditions, would not be speculative, but would then be a business. So if a person who has undertaken the business of futures and options now happens to pay the settlement fee and the compounding fee, now whether would be able to claim the deduction on account of this, though this is very dicey, but can be claimed against the business income if that expenditure can be said to be incurred wholly and exclusively for the purpose of the business, and it is not a payment in connection with an offense, or it is not an expenditure which is prohibited by law. Meaning thereby that in case that explanation to section 37 should not cover such kind of an expenditure. And therefore, for such person who has earned income by way of the business in futures and option, now can make a claim in respect of the settlement fee and this compounding fee as an expenditure which has been incurred, because this expenditure can be said to be incurred during the course of the business, and it is not in the nature of any penalty, or it cannot be said to be an expenditure which has been paid in connection with an offense. All that can be said is that the nature of this expenditure is the compounding fee. Now we are all aware that the compounding fee, though the judicial opinion is divided as to what is the nature of the compounding fee, whether the compounding fee paid now should be taken to be penal in character, whether it should be allowed or not. But then there are equal number of the judicial decisions which say, and I will be going to list them very soon before you, now which say that compounding fee are in the nature of the expenditure for the purpose of the business expediency, and it is not penal, can be taken as a measure of business expediency, and therefore it should be allowed. Now, first of all, I'll cite the decision of 172 ITD 157 Kolkata, in which the compounding fee was held, because the nature of compounding under various enactments acquires the same nature, and therefore it was held that the compounding fee was in the nature of compensation and was towards the business expediency and was held allowable. Now, another decision which comes to my mind is the Pune bench of the Income Tax Appellate Tribunal in 159 ITD 532. Now, in this case, there was some irregularity in dealing the foreign exchange. The RBI came out with a circular, and under which the compounding fee had to be paid, and was in fact paid, and therefore the question arose whether such compounding fee which has been paid pursuant to the scheme unveiled by RBI through a circular now can be said to be a business expenditure or not. And in this decision in 159 ITD 532, Honorable Pune bench of the Income Tax Tribunal now held that this compounding fee is not penal. Now, another decision is coming from the Mumbai bench of the Income Tax Appellate Tribunal, and it is reported in 46 SOT at page 258. Now, in this case, the compounding fee was paid on account of the fact that there was over dimension of a trailer, and because of which some violation took place, but then this violation was compoundable, and in fact it was compounded. And therefore the question arose now whether it should be allowed or not. So the court said, since this was an option given under the statute itself, and that option having been availed by the taxpayer, and therefore this expenditure cannot be said to be penal. And in 205 ITR at page 163, in which it was held by Honorable Gujarat High Court that the payment of compounding was in obedience to the provision of such law and was in fact as a measure of the business expediency, and therefore it was allowed. Though I am conscious that the Karnataka High Court is against on this aspect of the allowability, and therefore, as I said at the beginning, the judicial opinion is divided. But then a case can be made out in case of a person carrying on the business of the futures and options, that these expenditures now have been incurred for the purpose of the business, incurred wholly and exclusively during the course of carrying on the business. It is not in penal in nature. It has not been an expenditure in connection with any offense, and therefore is not held by explanation to section 37. Now there may be, I have been told, my friend Mr. Doshi from Raipur and from Mr. K.M. Roy from Calcutta, as to what would happen in case of, say, a sub-broker or a broker, now who also has gone in for this kind of a settlement scheme. Now the ratio of the allowability of the compounding fee against their business income would remain the same, and therefore taking advantage of all these decisions. And but then of course, I mean this settlement should not be on the basis of the admission of the guilt basis, but then it should be on the basis of the without admission of the guilt, or without admitting the factual conclusions and the legal conclusions. On that basis only then you can have a case. Otherwise, I mean, there may be problem. So Pavanji, I think that I have taken my 15-20 minutes time, I mean, which has given to me, and still if there are questions, then I will be there. But then we are eager to hear our senior Shri Vinod Jain sir.
Thank you, Rakeshji, for explaining the point of admitting guilt and not accepting guilt. There are some questions which I will ask you.